Hey everybody, it's your boy Jacob here today with part 13 of why I'm suing the city of Albert Lea. We got a juicy one today because we're talking about something that just happened in my lawsuit against the city of Albert Lea and the city council of Albert Lea that was summed up in one word by one of my buddies who's a pretty noteworthy journalist in the area. And that word, the word of today, is retcon. In storytelling, a retcon is when someone rewrites history after the fact to make a story work. And that's exactly what my attorneys are arguing the city of Albert Lea, Minnesota is doing in court. The city denied my cannabis business registration on July 28th of 2025. That's the decision under review. That's the date that matters. But instead of defending what they actually relied on at the time, which, might I remind you, was nothing, the city very publicly, on recording, the videos on YouTube, chose to defy state law because they didn't agree with how it was authored and legislated. I'll word it that way. That's it. That's why they denied my cannabis business registration on July 28th. The city's appellate brief instead leans heavily on media articles, political commentary, and state guidance that didn't exist yet. In certiorari appeal, the law is clear. The court can only look at the record as it existed when the decision was made. You don't get to fix an unlawful decision later by rewriting the justification and rewriting the history surrounding it. That's why my attorneys filed a motion to strike, asking the Court of Appeals to remove those improper sections entirely. And now, the Minnesota Court of Appeals has scheduled an oral argument for March 5th of 2026 in just a handful of months. There we will see a three-judge panel, I should say, that will hear this case. I've never experienced anything like that, so personally, I am actually looking forward to it as someone who wants to become a lawyer. This is all very fascinating and very educational to me, at the least. Outside of that, it's been a roller coaster. Continuing on, though, I just want to say, and this is really important, this case is about something bigger than me, bigger than all of us. It's about whether cities can ignore the law and then rewrite history to cover it up. I'll keep you posted as things move forward. And remember, the appellate hearing is open to the public. Reach out to the Appellate Court of Minnesota if you would like to attend. You could reference our court case number here if you are so inclined. With that all being said, let's move on to the actual motion to strike. You will see their typical header, the stamp of the Office of Appellate Courts, the filing stamp, the date. Pursuant to Minnesota Rules Civil Appellate Procedures 115.04 and 127, I'm assuming I'm reading the abbreviations right. I may be off, but I think that is right. Myself and my business respectfully move the court to strike portions of the brief of respondents, the City of Albert Lea and the City of Albert Lea City Council, that are not compliant with this court's rules. It's a really polite way of saying illegal. This motion is based upon the arguments below and all the files, records, and proceedings herein. As more fully described in the briefing, this appeal is from a single decision by respondents to deny a cannabis retail business registration to myself and my business. The city's brief, the city's brief, however, contains in its statement of facts extensive discussion of facts that are not facts, and even if they were, they're not, would be far afield from the matter before the court. Respondents editorialize extensively. They extensively editorialize, commenting on political matters such as the concerning aspect of how Minnesota's cannabis regulatory framework appeared to continue the recent trend of wresting historic regulatory authority away from municipalities and concentrating it in state agencies, and about how if other states legalize recreational cannabis, they may look to Minnesota as an example. But unfortunately, Minnesota has so far set an example of what not to do. Respondent's statement of facts is supported by at least 9 references to media coverage and a Minnesota Office of Cannabis Management guidance document, none of which appear in the administrative record. These are dated as early as January 2024, about a year and a half before the matter before the court arose, and as late as December 2025, after I had already filed my principal brief. Now keep this in mind as well. We were past the 20th state to recreationally legalize cannabis. We were basically in the middle. We aren't exemplary to anyone. We're in fact following all the other examples, if you could call that, set out by the previous states that legalized it. How are we going to be an example to anyone when we're not even the first? And frankly, a significant amount of states before us had their own legal issues. Almost all of them had lawsuits. You're going to have that when you're creating a new industry. That's just to be expected. What a lame opinion to rely on in an appellate court matter. Truly pathetic. Pursuant to Min R Civ App P 128.02 subdivisions 1 and 2, respondents were not obligated to provide a statement of facts. Because they did provide such a statement, however, it was to be relevant to the grounds urged for reversal, modification, or other relief. The facts were to be stated fairly, with complete candor, and as concisely as possible. And each statement of material fact was to be accompanied by a reference to the record, as provided in Rule 128.03, Min R Civ App P 128.02 Subdivision 1C. Respondents did not comply with these rules. Respondents, in my opinion, are attempting to continuously break the law, even in court. That's ridiculous. Matters such as the 2023 resignation of our Director of Office of Cannabis Management, or legislation that the OCM decided against introducing in 2024, are not relevant to the matter before the court today. Respondents' extensive commentary about, for example, the OCM's administrative rules being supposedly underwhelming and anticlimactic is an opinion and not factual. And because, pursuant to Min R Civ App P 115.04 Subdivisions 1 and 110.01, the documents filed with respondents, the exhibits, and the transcripts of the proceedings, if any, shall constitute the record on appeal. All of respondents' references to media stories and state guidance are improper. And remember, the only reason my cannabis registration was denied on the record on July 28th of 2025 was because the city went against the advice of Patrick Rigg, the city manager, and Joel Holstad, the city attorney, the mayor and several city councilors went against their warnings and advice because they so eloquently put it, they didn't like the state laws and how it was all legislated at a state level. That's it. That's why the word retcon is used today, because on the August 11th hearing, they created and fabricated all these lies about me to justify their prior illegal denial of my registration. Welcome to the government, folks. If the government can do this to me, they can do it to you. Keep that in mind. Anyways, let's carry on. Certiorari is, by its nature, a review based solely upon the record. Typically, when a quasi-judicial body, such as a county board, denies a permit, the reviewing court, should of course confine itself at all times to the facts and circumstances developed before that body. The court will strike documents included in a party's brief that are not part of the appellate record. Where a party submits newspaper articles not in the record, particularly when those are published after the decision appealed from, those are subject to being stricken. State agency issued documents are among the documents that may be stricken. Relators therefore respectfully request that this court strike in their entirety the following portions of respondent's statement of facts. Section A, which does not make any citations to the record, instead relying upon an article outside the record. Section C, which editorializes extensively, addresses matters not relevant to the matter on appeal, and relies upon several articles outside the record. Section D, which editorializes extensively, such by characterizing as a fact that the legislator wrote Chapter 342 poorly based upon the Albert Lea City Manager's opinion, and by characterizing OCM's administrative rules as underwhelming and anticlimactic, and as disappointing. Section E, which editorializes extensively, addresses matters not relevant to the matter on appeal, and relies upon articles outside the record. And Section I, which relies heavily on OCM guidance that is not within the record, and postdates the denial of my application. In addition, I respectfully request that the court strike all arguments contained within respondent's brief that rely upon documents not in the record, including OCM's guidance document. This is a significant remedy. The City Council's and City of Albert Lea's brief, however, is significantly non-compliant with this court's rules. The court should not allow that non-compliance to prejudice myself or my business. Dated yesterday, January 13th. I do want to say something. One, peep the sweater. Beautiful 100% cotton sweater with this amazing Slicks branding on it. Easily one of my favorite designs. It is very sleek, very modern. But two, personally, as someone who's wanting to become a lawyer one day and is a 4.0 GPA student at my college, I was looking forward to learning a lot about law from this. And I have. I really have. But I am wholly disappointed with how the city's attorney is choosing to handle their side of this matter. Excuse me, I keep yawning. I was expecting the city attorney to submit legal arguments that would blow me away, that would really give us a run for our money, that would really push the boundaries of law and the boundaries of what a city can do. Instead, what I've gotten is essentially grown adults throwing a tantrum, breaking everything around them, and then asking the adults in the room to fix it all so that they can try again and try to behave next time. The city shit the bed. That's it. You get to sleep in it. The judge can't retroactively fix everything. Instead, they have to rule on what was before the city the date they denied my registration illegally. I was truly expecting a phenomenal case, not a bunch of mudslinging. If I wanted to see people sling mud, I'd go to a farm and look at pigs. You know what I mean? Like, I just don't get this. This is asinine. It's insane. It's a mental illness. And as a citizen, setting all of this aside, it's really opened my eyes that the people in positions of power are some of the most corrupt and criminal of all of us. I'm not sure how better to phrase that. You know what they say? The only people that want to seek power over other people are probably people who are going to abuse that power. Yeah, they're going to distract us. Look at the criminals stealing from a store. Look at the criminals robbing other people. Ignore the criminals that are the ones writing and enforcing your laws selectively so that they themselves aren't barred from breaking those very laws that they enforce upon the rest of us. I grew up wanting to be a police officer. I grew up respecting firemen. I grew up respecting judges, respecting the rule of law. But now I am seeing that the rule of law only matters to the citizens and not to any of the people in positions of power or the people that are the elite rich. There's clearly two legal systems here. And clearly, the city of Albert Lea thinks rules for me, but not for thee, which is them. Or if they said it, it'd be rules for thee, not for me. You know, just so you understand what I'm saying here. I truly just lack the words to express how just absolutely disappointed I am. I used to look up to Patrick, our city manager. I used to admire Joel, our city's attorney. I used to respect and hold in high regard our mayor and the city council. These were all role models to me as a young adult who's in my 20s. But now, they're all just a fucking joke to me. I thought, and I think still, that people in positions of power should be held to a higher standard. Not the same standard. That's the bar. That's the bare minimum. But a higher standard. You are supposed to be an exemplary person in our society. Instead, you're pointing and shifting blame over to the state. And the state did their best job. You're the city council and the mayor and the city manager and city attorney. You guys are the ones that broke the law. You did. You're the criminals here. Not the state. Not me. You're the criminals. And you should be treated as such. That's all I gotta say. Again, if you want a hoodie like this, check the links. They're for sale. I love this. It's inspired by one of my favorite bands. Anyways, like, share, sub. Hit me up with any of your comments, questions, or concerns, and I'll do my best to answer everything in the comments below for you so that you hopefully don't have to go through this. And remember, this case is about something bigger than me and bigger than all of us. It's about whether cities can ignore the law and rewrite history to cover it up. Don't forget that. And don't get distracted. Always stay focused. If the city can violate the laws to take away my rights as a citizen, they can do it and will do it to you. Have a good day. Peace.